Bonjour. This is a first in a series of 6 videos discussing categories in the civil law. I put as a subtitle to this one, A Trip Inside the Civilian Brain. And you will understand. Categories can be used for many kind of purpose. We use them for filing. Filing is just a lot easier if you have something better than the simple alphabet. Categories, sadly, can also be used for discriminating people. And unfortunately, we have many examples in social and political life, but also in the law. But categories, and this is the better news, can be used for solving legal problems. Look at this example. Bill and Jane are a married couple. They have recourse to in vitro fertilization. However, because they could not have children on their own, they divorced during the process. And the question is, what happens to their frozen embryos? Can they be donated to other infertile couples? Can they be used for scientific purposes? Should they be placed under Jane's custody, as in the couple, she's the one more likely to be able to make use of those embryos? May they rather be destroyed? And answering this question much depends into which category you place them. You may view frozen embryos as human beings, and the concept of test tube baby. Or you may also view them as disposable things. After all, they are just material somewhere in a refrigerator. And that leads me to the summa divisio, to the principal division as it exists in the civil law tradition. And I'm going to cite to Roman law. I'll go back to Gaius, whom we visited in our second week of class. Gaius wrote, I know this is Latin, here is the English. Now, all the law that we make, use, or pertains either to persons or to things or to actions. But let's talk first about persons. You see that Gaius is insisting on the distinction between persons and things that we have visited earlier. And when I created the Journal of Civil Law Studies a few years after arriving here at LSU, we had a workshop, and the purpose of the workshop was to revisit the distinction between persons and things. And the papers were published in our very first volume. Look at the Civil Code. This is the Louisiana Civil Code, but you find exactly the same distinction in the French Civil Code. You find this distinction also in Gaius or in the Institute in the Justinian Corpus Juris Civilis, persons, things, obligations. You may view them in a linear manner, just like here, but you can also see relationship and connection. Persons are developing connections with things because, after all, persons own things and live in things and need things as vital resources. Things can be the object of obligations because we contract on those things. And you see, by the way, also the link and the connection between persons and obligations. But you can, and during our seminars, one scholar said, well, the relationship between these categories is dynamic. When you are discussing the embryo, the frozen embryo situation, okay, if you view them as test tube babies, you look at them as persons. If you look at them, however, as disposable things, that's where they are. But this is either or. If you talk about arranging for the adoption of the embryo, you are rather going here, you may be here, you may create obligations and arrangement with other persons. If you give it for scientific purposes, that will be a contract. You're there with obligation, but you may rather consider the embryo as a thing. You can place the cursor anywhere depending what you are doing when thinking about this embryo problem. And I promise that we will visit it and we will actually discuss it in our live class. Uh, I invite you with this slides to visit the Organization of Persons and Things in the Digest of 1808, and of course also in the present Civil Code. We'll discuss in the videos to come the present Civil Code. But I would like to look back a little bit at the past to show how this categorization can be troubling. Um, look at Book 1 of Persons, how it started back in 1808, of the distinction of persons and the privation of certain civil rights in certain cases. Article 1 say that the sex alone, which distinguishes men from women, establishes some essential differences between them with respect to their civil, social, and political rights. That is frightening. But that was the law back then. Article 2, whilst men are capable of all kinds of engagements and functions, unless disqualified by reasons and causes applying to particular individuals only, women are, by this sex alone, rendered incapable of various civil engagement and functions. Yes, sometimes to solve social problems, you got to change the law. That was clearly law that was in need of being revisited. Look at this now. Title 6 of Book 1 was addressing of master and servant. And you had a chapter 1 of the several sorts of servant. There are in this territory, that was back then the territory of Orleans, two classes of servants, to wit, free servants and the slaves. Persons or things. And here you see that this issue of slavery was a challenge on categorization. You had a chapter dedicated to slaves. The slave is entirely subject to the will of his master, who may correct and chastise him, though not with unusual rigor. Property, not completely. You can't do exactly what you want. You're not supposed to maim or mutilate the slave, or expose the slave to the danger of loss of life, or cause his death. One recognizes that thing, that there is also a human character. However, the slave is incapable of contracting any kind of engagement. He possesses nothing in his own right, can transmit nothing by succession, just like your dog. Can your dog inherit? Is your dog owning even its bone? Slaves may be prosecuted in the name of the government for crime. Can you prosecute your dog? You don't do the trial of an animal or no longer, but slaves could be prosecuted. You see that they're a sort of hybrid, for certain purposes regarded as persons, for other purposes as things. And keep reading. Slaves cannot marry without the consent of their masters. It means, a contrario, that they can marry provided they get the consent of their master. Children born of a mother then in a state of slavery, whether married or not, follow the condition of said mother. The mother is a slave, the child will be a slave. So, and this any enfranchisement, manumission of slave, made in fraud of creditor. What's that? How can manumission be done in fraud of creditor? The terrible thing is that, and you see that in the final sentence of this article, a slave could be mortgaged. You could borrow money using your house as a security. You could also use your slaves as security. And that was, by the way, one of the big problems at the time of the Civil War. Emancipation was creating a big economic problem in the South because slaves were instrument of credit. And many people would have been ruined because they had borrowed money using slaves as collateral, which is really erring on the side of looking at these human beings as things and not as persons. So these are just examples to show how you can really abuse these distinctions or ignore them or just do the wrong things. But the slides to come will show you a much more productive and positive use of these categories in the civil law. Thank you for your attention.